Good afternoon, everyone. We're going to go ahead and get started. We have, as you can see, an absolutely full house. So thank you for joining us today. My name is Brad Sears, and I'm the Associate Dean of Public Interest Law at UCLA School of Law. And I'm very excited to kick off our second annual series of the Margaret Levy Fellowship Program. Before we start, we're going to have an announcement from one of the students from the Native American Law Students Association, Melody Meyer.
Thank you. Good afternoon, everyone. Just going to read the land acknowledgement for UCLA quickly. The David J. Epstein Public Interest Law and Policy Program acknowledges the Tongva peoples as the traditional land caretakers of Tongvar, the Los Angeles Basin, and Southern Channel Islands. We are grateful to serve the indigenous peoples of this place. We pay our respects to our ancestors, our elders, our relatives and relations, past, present, and emerging. Thank you.
Thank you. So the Margaret Levy Fellowship Program is a program which brings an outstanding practitioner in public interest law to the UCLA Law campus several times a year, and unlike most visits, the visit's designed to last 2 or 3 days to give the speaker a variety of opportunities to meet with our students and alumni, and to give students an opportunity to meet not only in settings like this, but actually on one-on-one with these public interest attorneys. So we really encourage you to watch out for the upcoming speakers in this program. And more broadly, to watch out for the events and the theme for the Epstein program's events this year, which is defending democracy. We'll be having events through our democracy is in need of defense, as you may know, and we'll be having programs throughout this semester and next, including our second Levy Fellow for this year, who will be Kate Kendall. Kate has a long history working on LGBT rights at the National Center for Lesbian Rights. She's currently an interim legal director for the Southern Poverty Law Center, and she's also doing a lot of work around judicial appointments. There are a couple people I'd like to thank before we start today's program, and the first is that we're very honored to have with us today the woman who made the Levy Fellowship possible, Margaret Levy, one of our alums, so thank you. And then I also want to thank Karen Wong, who's done such a great job in organizing all of this, and finally Brenda Kim. And finally, Brenda Kim, who usually is not in the room to be thanked, but she is also very good. And with that, I'd like to introduce and thank a final person, Dean, who has really put her money where her mouth is and showing her commitment to public interest careers at UCLA Law, our Dean, Jennifer Manuka.
Thank you so much, Brad. And I want to echo the warm thanks to Karen and to Brenda, and especially to Maggie Levy, who has made this possible. And I am so excited that you all get the chance today to hear from Dale Ho, because there really isn't anybody on the front lines of defending democracy more than Dale. So it's really fabulous to see you here and to see this extremely full house for what I know is going to be a really engaging talk and conversation. Sadly for me, I don't get to stay for it. We have a faculty job candidate here also giving a lunch. So it's another example of how there's so much going on here that you can't do it all. But I'm really disappointed that I'm not going to get to be here for your actual talk. Now, I know that it's a whirlwind couple of days for you. We really appreciate that you're here with us for several days, and we're filling that time with meetings and presentations, and there's more to come. And so we are so grateful, Dale, that you've come here to share your insights and knowledge with us and with our fabulous Epstein program in public interest law and policy. So before I even give you the official introduction, let's give Dale a really warm round of applause. Now, Dale has an incredibly long and impressive history on the front lines in voting rights. He's the director of the ACLU's Voting Rights Project. kept him a little busy lately, I think it's fair to say. He's the person who oversees voting rights litigation and advocacy, and he's one of the attorneys who argued successfully the case of Department of Commerce versus New York at the U.S. Supreme Court, which was challenging the inclusion of a citizenship question in the census. So congratulations, Dale, and thank you for your important work. As we all know, voting rights is a focus of a broader conversation going on today about the future of democracy and the shape of democracy. And there's a number of threats to the ability of all eligible citizens to vote. And these threats have a huge impact on local, state, and federal election results, potentially past and also future. Dale frequently comments on voting rights in the media and in testimony before Congress and other official panels. He's an adjunct clinical professor at NYU Law, a former assistant counsel at the NAACP Legal Defense Fund, and a former associate at Fried Frank. He's a graduate of Princeton University and the Yale Law School, and he clerked for Barbara Jones of the U.S. District Court for the Southern District of New York and for Robert Smith of the New York Court of Appeals. We're very lucky to have him with us this semester as our fall Margaret Levy Public Interest Fellow. And I'm just thrilled that Maggie Levy can be with us today to be part of it. She is a proud UCLA Law alum and friend, and it was her generosity and her vision that helped make this fellowship program a reality. And so how wonderful that you get to be here to also be part of this wonderful conversation. And so one more time, let's give a warm brew and welcome to Dale Hunt.
Thank you so much for that kind introduction, Dean Manukin. And thank you to Maggie Levy and also to Karen and Brenda for inviting me here and giving me the opportunity to spend a little bit of time with you all over the next few days. It's really a tremendous honor. I just want to thank you also all for taking time from your busy lives as you get the new semester underway to come and listen to me yap for a couple of minutes. My name is Dale Ho. I'm the director of the ACLU's Voting Rights Project. I supervise our voting rights litigation around the country. I've spent most of the last 10 years of my career fighting what is a new wave of voter suppression laws that have emerged around the country. Most of these laws are new, as I said, and I want to just tell you a little bit about that experience and how I understand the fight that we're in today, which is a battle against the most ferocious assault on voting rights that this country has seen in a generation. I want to tell you a little bit about that experience, though, by starting with what I regard as kind of the conventional way these fights have been described in policy debates, in the public, in the media. And I want to tell you a little bit about why I think that conventional narrative is a little incomplete. So let me start there with the conventional wisdom about what's happening on voting rights now. And it's something you hear, a narrative that you hear sometimes from a lot of progressive and left-leaning groups, from members of the Democratic Party. It's sometimes the narrative that's used in the media. And here's kind of how this narrative goes. There's been a war on voting over the last decade. Before that began, the United States already had pretty dismal turnout compared to most of the Western world. We're not even in the top 30 among the 36 Organization for Economic Cooperation and Development countries, the OECD countries. In that context, we ought to be doing everything that we can to make voting easier, to bring more people into the process, to get a truly representative and responsive government. But instead, we've been going backwards. In 2011 and 2012, according to a report by the Brennan Center for Justice, 19 states passed 25 laws, and governors in those states issued 2 executive orders, making it harder to register to vote or to cast a ballot. They do this in the name of fighting against voter fraud. Strict voter identification requirements, in particular, are purportedly necessary to prevent a wave of in-person voter impersonation, right? Someone goes to the polls pretending to be someone that they're not, so we need to force voters to show identification at the polls. A study by Justin Levitt, who's a professor at another law school in the area, a little bit, I actually don't know in which direction. I'm from New York, that way. Justin did a study on this and found that since the 2000 election, there have been 41 cases, credible cases, of in-person voter impersonation at the polls, a period of time in which over 1 billion ballots were cast. You're more likely to be struck by lightning twice than to be impersonated at the polls. So we don't have a problem of fraud, right, or in-person voter fraud. So why are these laws getting passed? Well, the conventional narrative goes something like this. For partisan gain. The Republican Party tends to do better in lower turnout elections, and they have decided to pursue a strategy of reduced turnout. We see it in laws that restrict access to registration and voting, but we also see it in negative campaigns, in disinformation on social media designed to drive wedges between factions on the left, to stoke and divide discontent, and to reduce the desire amongst people on the left to participate. According to this narrative, the prescription is simple. It's twofold. One, we need to protect voting rights, and whereas protections for voting rights in the past were largely race-based, the Voting Rights Act, for example, prohibits discrimination on the basis of race. What we need to do now is protect voting rights for everyone. We should make it harder for states and localities to erect new barriers to registration or voting for anyone, regardless of whether or not those new barriers sound like they're racially discriminatory. Second, we have to boost participation with voter-friendly laws and policies, because the low turnout that we're seeing today is something that actually predates the latest surge of voter suppression, and we need to look at policies like automatic voter registration, like most Western European countries do, put the burden of registration on the state rather than on citizens, maybe make Election Day a national holiday, have policies like no excuse absentee voting so that people can vote from home and do it not on one day out of the year, but when it's most convenient for them, so that everyone can, who wants to participate, can do so without unnecessary burdens. So maybe I'm in a little bit of a provocative mood today, I don't know, or I'm just ornery, but I want to tell you that that conventional story, it's not wrong exactly, it's not false, but it's not fully accurate either. It's incomplete. It commits what I view as a very, very serious error of omission, which leads to a misdiagnosis of the problem that we are facing today, and it leads to prescriptions that are, in my view, at best, only partial solutions. And here's the omission that that conventional story commits. It neglects the role that race and racism have played and continue to play in struggles over voting rights in this country. Those struggles, when you look at them closely, give you a story that's not one of inevitable or linear progress, of ever-expanding access to the franchise, but instead a story that's full of contradiction, contestation, contingency, and backlash. And the moment that we are experiencing today, although it seems new, is actually in many ways an echo of where we've been in this country before. It's the latest chapter in a story that we've been living for a very long time, and it recapitulates many of the same beats that we've experienced since the founding. So I know that this lecture is supposed to be about new threats to the right to vote, and I will get there, I promise, but I want to just back up for a second and talk a little bit historically to provide a little bit of context for what I want to talk about today. So I hope you'll indulge me for a moment. And I'm going to go all the way back to the founding, right? The story that's told at the founding that we, on the left, sometimes hear, is that at the founding, only rich white men could vote, But over the last 200 or so years, the electorate has slowly, in fits and starts, expanded in concentric circles to get to where we are today. And that's not actually totally accurate. Actually, at the founding, it was not the case that only white men could vote in some states. In New Jersey, for example, women could vote if they satisfied the property requirement. Free men of color who satisfied their state's property requirements could vote in a number of states, including New Hampshire, Massachusetts, New Jersey, and North Carolina. And I want to linger on North Carolina there for a second, because that's... We'll get back to North Carolina later today, but that's fascinating if you think about it, right? A state where you have chattel slavery, right, on the basis of race, also allows black men, only men, right, if they satisfy the property requirement, to participate, right, in representative government, right? At the time when the founding document is ratified, right? That's really, really interesting. It's such a contradiction when you think about it, right? Obviously. That didn't last in North Carolina. The 1835 Constitution of North Carolina was explicit about that. It eliminated the franchise for black men altogether. That was in the wake of Nat Turner's rebellion. That same Constitution also relaxed the property requirement for white men, right? So you had expansion of the franchise at the same time as you had contraction of it. Not a unidirectional sort of march towards universal suffrage, but contradictions, right? And that's not something that that's something that you might not apprehend if you just view voting rights through a sort of race-neutral expansion of democracy lens. The Reconstruction and post-Reconstruction redemption periods tell a similar story. The Reconstruction amendments abolished slavery, guaranteed equal protection of the laws to everyone in this country, made it so that anyone born on American soil would be a United States citizen and enjoy the immunities of that. And the 15th Amendment banned discrimination in voting on the basis of race. And the change that flowed from those amendments was stunning. Right? By the 1880s, you look at state legislatures in the South, and in a number of those states, the legislatures consist of 40% or more members who are black men, right? 15 years earlier, they're property. 15 years later, they're making laws, and they're almost a majority in 3 former Confederate states. Just amazing to think about that, right? But that didn't last, right? The backlash to that moment was swift. The constitutions in the South of the 1890s and 1900s contained a bevy of new restrictions on voting that, while facially neutral, had the purpose and effect of disenfranchising African Americans. Literacy tests, poll taxes, felon disenfranchisement laws, and all of them with exemptions like grandfather clauses that are built into the system to make it so that they do not affect white men to the same extent that they affect black men. Now, all of them are justified as being necessary, supposedly, to protect the integrity of the ballot box and to prevent against fraud. You need a poll tax, right? Because if you don't have a poll tax, poll people will just sell their votes. That's literally the argument that's being made in editorials around the country in in the early 1900s. So a generation of progress that we saw after the Civil War gave way to more than a half century of black codes and Jim Crow. Then we get to a third wave of democratic expansion in this country in the 1960s. Right? In 1964, those practices that had been adopted more than half a century earlier had done their job. Right? 1964, you look at Mississippi, less than 7% of African Americans are registered to vote at the time that Freedom Summer takes place. Alabama, in 1965, when the Selma to Montgomery March takes place, it's under 20% of African Americans who are registered to vote. But from that march and from Bloody Sunday, right, from that terrible crucible, a new covenant was formed protecting voting rights regardless of race in this country in the form of the 1965 Voting Rights Act. Literacy tests fell, not just in the South, but soon across the country. Poll taxes were struck down by the Supreme Court a year later. And for decades, we had a consensus in this country that racial discrimination had no place around the ballot box. Now, that's not to say we didn't have racial discrimination in voting. That's not to say that we didn't have disputes and contestation about voting rights. But we had something of a bipartisan consensus, even as power changed hands between the parties. Even as Jimmy Carter won in '76, and Reagan won in 1980, and Clinton in '92, and George W. Bush in 2000, and as the pendulum swung back and forth, that consensus still held. Richard Nixon signed reauthorizations of the Voting Rights Act in 1970 and 1975. Ronald Reagan in 1982 didn't just sign a reauthorization of the Voting Rights Act, he signed an expansion of it, an amendment to Section 2 of the VRA, which applied across the entire country, and which provided that not merely intentionally discriminatory voting laws would violate federal law, but laws that had discriminatory results in voting would violate federal law. Ronald Reagan signed that into law and called it the crown jewel of American civil rights protections. In 2006, when the VRA came up for reauthorization again, it passed 390 to 33 in the House, 98 to nothing in the Senate, and George W. Bush signed it into law. Now, I mean, for the last decade, Congress hasn't even been able to pay our bills, right? You know, can't even raise the debt ceiling. So, I mean, just think about that for a second. That's barely over a decade ago. But then something changed. Before the 2012 election, 24 new restrictions on voting rights, something like we hadn't seen in decades in this country. Why? Why suddenly do we have that change? Why suddenly does that bipartisan consensus break down? Well, if you want to understand what's happening in the run-up to the 2012 presidential election, easiest thing to do is look at what happened at the preceding presidential election in 2008. And I want to identify 3 trends that made that election really like a bolt of lightning to what was then the current alignment of the political parties on issues of voting rights. As I think everyone knows, this country is getting more diverse. Right? Just between 2004 and 2008, we saw a massive increase just in the size of the population of communities of color. The 2008 election was the most diverse electorate up to that point in our nation's history. Voters of color constituted over a quarter of the nation's eligible electorate for the first time in our nation's history. That's the first trend. The second one is that participation by voters of color skyrocketed in 2008 when you compare it to 2004. If you just compare the total numbers of ballots cast in a 4-year period from 2004 to 2008 and break it down by racial and ethnic groups, you see that there were 15% more total ballots cast by African Americans in 2008 as compared to 2004, 20% more ballots cast by Asian Americans, 25% more ballots cast by Hispanics. I'm using the categories utilized by the Census Bureau. For non-Hispanic whites, 0.5% more ballots cast between 2004 and 2008. So non-Hispanic whites continue to grow in gross total numbers, but as a share of the electorate, shrunk dramatically. Third trend, racial polarization in the electorate. Now, if you look at how Obama did in 2008 and compare it to how John Kerry did in 2004, with these newly emerging segments of the electorate, he did a lot better than Kerry. So he got plus 7 percentage points more among black voters than John Kerry got, plus 6 percentage points more among Asian voters than John Kerry, plus 14 percentage points among Hispanic voters. Now, he did better among non-Hispanic white voters, too, plus 2 percentage points. And he was very effective in some predominantly white places. I think I remember the night watching the returns of the Iowa caucuses in 2008, and the media just being stunned that Obama had carried a state that was 95% white. But he bled white support in a number of places. If you look at the national numbers, you miss out the story of what's happening at the regional level. Obama was flat amongst white Democrats with John Kerry in 6 states, and he did worse than John Kerry among white Democrats in 3 more. Now, I don't know how old you were during the 2004 election, but if you compare the 2004 and 2008 electoral environments, it's pretty remarkable to do worse amongst some members of your own party. You had a very unpopular president of the other party. You had 2 very unpopular wars. You had a country that looked like it was on the brink of economic collapse. And you're also comparing Barack Obama to John Kerry in terms of political skill, right? So it's really remarkable when you think about that, right? But these 3 trends, right? More people of color in this country than ever. More voters of color than ever, because turnout skyrocketed. And Obama running up the score amongst voters of color. Those 3 trends put together gave us our nation's first black president. And when you understand that, then what happened before the 2012 presidential election starts to make a lot more sense. Because the wave of laws that we saw in 2011 and 2012 that came like a bolt of blue, like a bolt out of the blue. Like, we were not expecting this. I will admit, I was at the NAACP Legal Defense Fund at the time. I will admit we were completely caught off guard. We were getting ready for redistricting. The census had just happened in 2011. And this wave of laws that suddenly make registration and voting harder happens. They're facially neutral, and they make registration and voting harder, but they don't make it harder for everyone. Right? They make it harder for some people. Let me give you some examples. Florida, in 2011, passes a law that imposes new restrictions on voter registration drives. What does that mean? It means that if you want to touch a voter registration form filled out by anyone other than a member of your immediate family, you need to register with the state before you do that. You must file monthly reports, right? You must file monthly reports about the number of forms that you hand out and the number of forms that you collect. If you turn in those forms after 48 hours, you turn in those forms 48 hours after you collect them, or you face fines of $50 per form per day late. Right? This was brought to you by the small government wave of 2010. Right? The League of Women Voters immediately canceled all voter registration activity in the state. Now, who uses voter registration drives? Well, according to the census data that we looked at, it was between 15 to 20% of Hispanic and African American voters in Florida had registered through a drive, as compared to 6% of white voters. I'm sure that's just a coincidence, right? Florida also cut 5 days of early voting, including early voting on the last Sunday before Election Day. Anyone in this room know why that last Sunday might be important? Churches, right? Souls to the polls activities. We looked at the data again. Black voters, about 19-20% of voters in Florida. They were 33% of voters on the last Sunday before Election Day. I'm sure that, again, was just a coincidence. Right? Texas and South Carolina enacted strict voter identification laws. You do not have one of a limited set of forms of government-issued photo ID. You cannot vote. No safety valve. No, I signed an affidavit swearing up and down I am who I say I am, and provide you with 10 other forms of ID. You're just done. You can't vote. Right? Why is that a problem? I bet everyone in here has some form of government-issued photo ID. It's not something that would make voting harder for most of the people in this room, probably not any of the people in this room. Okay, but in Texas, ID possession varies by rate. There are statistically significant differences in terms of race in terms of who possesses one of the forms of government-issued student ID. You've probably heard the expression, everything's bigger in Texas, right? It takes a long time to get to an ID issuing office in Texas. Only 1/3 of counties in Texas, 1/3 of counties in Texas do not have a Department of Public Safety, their equivalent of a DMV. So 1/3 of counties do not have an office where you can obtain an ID card. You have to go to the next county. And in some parts of Texas, that means a round trip of 200 miles, because everything's bigger in Texas, right? For people who are legally prohibited from driving, right? Because they don't have a license to begin with. Access to vehicles also varies by race in Texas. Now, these restrictions, most of them were blocked under Section 5 of the Voting Rights Act, which required states and counties with the worst histories of discrimination to obtain federal approval before making changes to their voting laws. And so a lot of these laws did not go into, the ones I named in particular, did not go into effect before the 2012 presidential election. But in the spring of 2013, in a decision Shelby County versus Holder, the Supreme Court struck down the part of the Voting Rights Act which determined where those federal preclearance obligations would have to be met. In a 5-4 opinion by Chief Justice Roberts that proclaimed things have changed in the South. Justice Ginsburg famously warned that getting rid of the federal preclearance process at that time was like throwing away your umbrella in a rainstorm just because you're not getting wet. And sure enough, the downpour came. I want to take us back to North Carolina, which I mentioned earlier, which I think best encapsulates what I'm talking about. Now, North Carolina was the closest state in the 2008 presidential election. It was decided by about 20,000 votes, had record levels of black turnout. In January of 2013, the North Carolina House passed a strict voter identification law, not unlike what we saw in Texas and South Carolina, except you could vote with any form of government-issued photo ID under this law. So issued by a government, it's got a picture on it, you can vote, you're good to go. It passes the House and then it goes to the North Carolina Senate, where it sits with no action on it for several months. In the interim, the Shelby County decision is decided, releasing North Carolina from its obligation to get federal approval for changes to its voting laws. The next day, the chair of the North Carolina Senate Judiciary Committee says, good, now we can go forward with the full bill. No one knows what he's talking about at that point, because the only bill that we've seen is this ID law. Several weeks later, with 2 days left in the legislative session, the night before it is to be heard in committee, the full bill is posted online. It goes from being about, I think, 12 or 13 pages to being over 50. It no longer has only an ID requirement. It cuts a week of early voting in which about 900,000 people had voted in 2012. It eliminates same-day registration, which about 100,000 voters had used. It requires the discarding of ballots if they are cast at the wrong precinct, even if by no fault of the voter. It eliminates pre-registration, a practice by which 16 and 17-year-olds could submit a voter registration form early when they get their driver's licenses and then automatically become registered to vote when they become of age, something that 150,000 North Carolinians had used. We sued the day that then Governor McCrory signed that bill into law. And here's what we learned in discovery in that case. That in the months between when it passed as a strict ID law in the House and when it sat in the Senate with no official activity taking place, in fact, there was a lot of activity taking place below the surface. Legislative staff sent emails to the North Carolina Board of Elections asking for racial breakdowns of who uses early voting, who uses same-day registration, and who uses absentee voting. Come back to absentee voting in a second. Legislative staff also sent emails to the University of North Carolina asking for a breakdown of who holds UNC student ID cards. Emails were also sent to the North Carolina DMV asking for racial breakdowns of who has driver's licenses in the state and who has non-driver's state ID cards. We know now, we didn't know this at the time, that the Republicans' consultant for their redistricting plan, a man named Thomas Hoffler, actually built a map of North Carolina A&T, the largest historically black college in North Carolina, which had the location on it geocoded of every student at the university and a notation for whether or not they had ID or not. When the bill changed, it was with data that showed that 70% of black voters in the 2008 and 2012 presidential elections had voted early in that state as compared to about 50% of white voters. That black voters were about 50% more likely to use same-day registration as white voters. That driver's licenses were disproportionately held by whites in North Carolina. Student ID cards, public assistance ID cards, municipal employee ID cards, which would all have been acceptable forms of voting under the original version of the House bill, were removed from the Senate version of the bill, which eventually became law, and were no longer permissible for voting purposes. Absentee voting, which the North Carolina Board of Elections data revealed was disproportionately used by white voters, was exempted from the ID requirement. The U.S. Court of Appeals for the Fourth Circuit, in a unanimous ruling in 2016, struck the law down as unconstitutional, finding that it had targeted African American voters with, quote, almost surgical precision. And it's pretty remarkable. It's pretty remarkable to get a Court of Appeals to find that a state legislature acted with unconstitutional discriminatory intent. I think I remember being told as a baby lawyer never to ask a Court of Appeals to do something like that, but we had pretty good facts. What I think that case shows, and all of the cases really, or many of them, that we've litigated since 2011, 2012, that the debate between whether or not what we're seeing in this country is motivated by partisanship or by race is a misguided debate that commits two basic, the premise of the question commits two basic errors. It presupposes a kind of race-blind politics that has never existed in America, and it assumes that racial discrimination is simply a sort of irrational prejudice that some people at some point in time exhibited rather than a system of power. As if Jim Crow and mass disenfranchisement before the Civil Rights era were solely about inflicting dignitary harms on African Americans, which was, of course, one of the goals, right? But they were also designed to preserve a political system of white supremacy. In my view, today's voting rights disputes are very different than what we've seen in the past, of course, but they are also not just about partisanship. They are very much about race and inextricably bound with our country's history of racism. Now, if that's right, what do we need today? Right? Well, yes, we do need affirmative voting reforms that make voting easier. Yes, we do need things like automatic voter registration. I support automatic voter registration, just to be clear about that. I don't mean to poo-poo it. But reforms like automatic registration are not sufficient. Right? Most states, 19 states, have adopted automatic registration since 2017. It's really remarkable. I don't want to underplay the significance of that. It's a very important philosophical shift to make registration something that the state does rather than something that we expect of individual citizens. It's the majority practice in democracies around the world. It's about time that we joined it. But most states that practice automatic registration do it through the DMV only, right? When people get driver's licenses. As early as the 1993 National Voter Registration Act, the Motor Voter Law, we understood that providing voter registration services only to people who drive is not sufficient. The NVRA is known as motor voter, but the provision of the law that I care most about is Section 7, which requires states to provide voter registration services not just at DMVs, but at public assistance offices, and it's at offices that provide services to people with disabilities. Our opposition to strict voter identification laws grows out of a recognition that not everyone gets a driver's license, and in particular the people that don't are disproportionately made up of the most vulnerable members of our society. Automatic registration through DMVs is good, it's important, but it literally does nothing for those segments of our society. I pointed this out once to a booster of AVR who got really impatient with me and just said, look, it's 200,000 more voters in this state. Do you want those or not? And of course, I want them, right? Of course I do. But just trying to increase the number of voters we have, just trying to address the problem of turnout that we do have in this country without being attentive to issues of equity is insufficient. It also won't address the many other forms of voting rights violations that we see today that are not merely in the form of restrictions on registration and voting. It does nothing to prevent efforts that try to dilute the voting power of communities of color. We see a number of states since the Supreme Court's, counties, I should say, since the Supreme Court's decision in Shelby County that have reverted to methods of election, which I'm happy to talk about later, that although everyone is permitted to vote, reduce the voting power of minority communities in a way that is just as effective as denying the ballot altogether. The census case that I argued in the Supreme Court earlier this year was about an effort to dilute the representation of minority communities. I don't want to spend too much time on it today because I want us to have a conversation, but for those of you who don't know, the administration tried to put a citizenship question on the census, something that we hadn't had in about 70 years. The Census Bureau's own estimate, so not mine, not my experts, don't take my word for it. The Census Bureau, the administration's own estimate was that putting that question on would cause 9 million people not to respond to the census. Just to put that in perspective, that's more people than in our 11th largest state, New Jersey. If you put them all together and made them a state, they would have 12 seats in Congress and 14 votes in the Electoral College. Because the census counts are used as the basis for apportioning representation for states in Congress and for drawing district lines within states, the effects would have been devastating. California would most certainly have lost a seat in Congress, along with New York, Florida, Illinois, Arizona, and Texas. And within states across the country, we would have seen a reduction of representation in urban and diverse areas and power flowing out to rural, disproportionately white areas of those states. Just increasing access to voting is not going to solve or address those kinds of attacks on voting rights. Easier access to voting will not solve the problem that by 2040, 70% of the country, if current population trends obtain, will reside in just 15 states. Right? Put that another way, that means 30% of the country will have 70 seats in the Senate and outside representation in the Electoral College. It's incumbent upon folks who care about voting rights to see connections between restrictions on the ability to participate and other kinds of attacks on fair representation of voters of color. And that's impossible if we do not acknowledge the role that race has played and continues to play in struggles over voting rights. Now, that diagnosis implies a prescription that is not as simple as we sometimes make it, and I'm guilty of this too. The ACLU, our voting rights slogan is "Let people vote." Right? That's obviously, I think it's a good slogan. Right? It's simple, it's easy to say. But the fact is that one thing that conservatives are right about is that in many parts of the country today, in 2019, it is easier than it has ever been for some people to vote. But that's not true everywhere, and it's not true for everyone. There are contradictions of our time, as there have always been throughout American history. The right to vote is expanding at the same time that it's contracting. I believe that we will get past this moment. We can get past it. But we have to be clear about the threat that we face today. We have to be clear that it is just the latest struggle, the latest chapter, I should say, in a struggle that's been ongoing since the founding. So thank you very much for giving me the opportunity to talk to you today. And
So we're going to pass out cards if you have questions. Thank you so much, Dale. That was amazing. Karen's going to be passing out cards. You can give her any questions. I wonder if you would just start out, since part of the goals of the series is to encourage people to do public interest law. Telling us a little bit.
Is that easy?
Tell us a little bit more about your career path. In particular, if people want to do voting rights work, what should they be doing now in law school and thinking about after law school?
Right. So I'm not going to tell you that there's like some series of boxes that you should check to have a particular career. You know, obviously there are, you know, you can't, you know, skip class, but you know, I think law school, you know, it's maybe your last time in school, and it's a good opportunity for exploration. So I do think people should not just be instrumental about their legal education, right? Not just try to set yourself up for the next accomplishment. Explore what you want to do. You know, my 1L summer I spent at the War Crimes Tribunal for Rwanda. My 2L summer I split between a firm and a place called the Southern Center for Human Rights, which does capital defense work. So I didn't do any voting rights or election work or partisan work or anything like that while I was in law school, and I still ended up doing what I'm doing today. You can't go wrong doing things that you're passionate about. I don't know if I gave you the answer to your question.
That's great. With the losses at the federal level, can you tell us how your strategy has changed in terms of going to the state level or other things you're doing for the law?
Yeah, so we've lost a lot, right? I want to, you know, I talked about cases that we've won, but we and other voting rights advocates have lost a lot of cases over the last 7-8 years, you know. Blocked the strict voter ID law in Texas, but strict voter ID got through in Wisconsin, blocked the early voting cutbacks in Florida and North Carolina, but Ohio got rid of a week of early voting, got rid of same-day registration. My team lost the case about voter purges in the Supreme Court in Ohio. It's a tough place to be in. I think Trump just passed the number in his 2.5 years as president of judges that Obama hit at 4 years. So the judiciary, the federal judiciary is not necessarily getting better for us. We have tried litigating some cases in state court. The problem with that idea is there's frequently a mismatch between the states with the worst problems and the best state Supreme Courts, right? Like, you've got a great state Supreme Court here in California, and you do have voting rights problems here in California, absolutely. But they're of a different sort in Mississippi and Alabama and Louisiana. But we're trying to adjust to the difficult context in which we're operating.
All right, if you have questions, if you can pass them to the end. First question is more kind of on career paths. What organizations should students think about volunteering for or supporting through donations or otherwise to help with voter turnout protection?
Right. Well, depends where you want to be, right? There are some places here in LA that do the kind of work that I do. MALDEF, for example, is a terrific organization, and they have offices around the country, but a big one here in LA. AAAJ also is here. Common Cause is here too. They all do terrific work on voting rights outside of LA. There is an outside of LA. You wouldn't know it from the weather out here. I'm about ready to move. in New York, we obviously are there. The Brennan Center for Justice, in DC, the Lawyers Committee for Civil Rights, the Campaign Legal Center, a bunch of organizations doing the kinds of voting rights work that we do.
Yeah, I think the next question also kind of deals with organizations, but in terms of just coordinating efforts among, I think, different groups and different strategies. So the question is Verified, Indivisible, the ACLU, Swing Left, Vote Save America. How much is there a national coordinated strategy between your work and other efforts?
It's not as coordinated as I think we would be in an ideal world. Every organization kind of has its own niche and pursues its own priorities. We try to not duplicate what other groups do. So, after the census decision from the Supreme Court, the questions put to me, well, what are you going to do now to educate people that there is no citizenship question on the census, and to get out the count, get people to actually participate in the census? And frankly, I just think the ACLU is not the best situated organization to do that kind of work, right? We're a bunch of pointy-headed lawyers in New York and DC, and of course with our affiliates around the country, but we're not the kind of grassroots organization that has a lot of direct community contact that's going to be able to kind of carry that message in a credible and effective way. So we played our part. We won the case. Other groups, I think, have to play their part to make sure that people return the forms.
Great. I think the next question is just motivated by people wanting to kind of stay up to speed on these issues, kind of what are good listservs beyond sources of information, books, articles. How do people kind of get up and stay up to speed on this issue?
I mean, so part of my job is being on Twitter. And it's like I can't read a New Yorker article anymore. It's like my attention span is shot to hell. Try to avoid Twitter if you want to really understand what's going on. But if you must, follow Sam Levine, a reporter at Huffington Post. He's covering the voting rights beat for them. He's really, really good. Tierney Sneed over at Talking Points Memo. Ari Berman, who writes for Mother Jones, he writes longer form pieces now. He's not chasing breaking news, but he wrote a terrific book, Give Us the Ballot, which I think really does a lot to explain the voting rights fights of today. But those are at least the media sources that I would rely on for fast-breaking voting rights news.
Great, thanks. The next question has...
Rick Hasen's election law blog, another law professor who teaches at a different law school in the area.
The next question has to deal with incumbency protection laws. So the question is, at the state level, there are incumbency protection laws and rules that limit turnout, like the New York primary registration law. In many cases, this results in an older, wider electorate. Do you view these laws as part of the historical racial bias in voter laws, or a separate issue?
I mean, I think what that question points to is that we always have to be attentive to the unintended consequences of well-meaning reform, efforts. So a century ago, progressives had this idea that was, if we can make, they were so sick of partisanship, if we can make local elections not coincide with national ones, we can departisanize those elections, right? We can make them about local issues. Maybe we'll even make them nonpartisan elections entirely, right? Which is the case in some places. And so local elections will less be about, warring tribes and more about how do we solve actual problems of this community. I was going to say how do we make sure the roads are paved, but 100 years ago I don't know if that was actually the issue. Was how do we get indoor plumbing everywhere. That well-meaning reform, I don't think really turned out the way that it was intended to, right? Because a lot of local elections have single-digit turnout. We vote maybe too much in this country, sometimes people say, right? When you delink those elections, you just get very little voter participation in local elections. After the Michael Brown shooting, right? And people looked at Ferguson. A lot of people looked at Ferguson city government. They're like, "What is going on here? How do you have this city that is, majority black, and have this all-white power structure? All the people in key positions of power are white." We brought a case challenging the way that the school board is elected in Ferguson. The student body of the Ferguson school district, 80% black, right? as recently as 2014, not a single black member of that school board, right? And part of the problem is when those elections happen. So, turnout is so low. You have to be careful about unintended consequences of reform. And so, we support automatic registration, but I think we have to be attentive to whether or not it's hitting the equity concerns that we have. And as, like the New York primary rule, it's there to make sure that one party doesn't go around mucking around in the other party's primary, right? You can't just have people switch over from Republican to Democrat, a week before the election and messing up the internal functions of that party. But obviously, that deadline is way too far in advance, and it ends up locking a lot of people out of that process.
Great. And the next question is about Shelby. And the question is, how about responding to Shelby by requiring pre-clearance everywhere? But if you could broaden that, just based on Shelby, is there really anything Congress could do that would bring back pre-clearance?
Well, that's a good question. Congress is not going to do it in its current form, right? It's become a partisan issue in a way that the VRA was not before the 2008 election. Like I said, it passed 98-0 in the Senate. In 1982, some people proposed making pre-clearance an obligation across the country. And setting aside the incredible amount of resources it would take for the Department of Justice to review every voting change made, all the way up from the state down to like the tiniest jurisdictional level, and assuming you could actually muster the political will to build a voting section in a civil rights division that was big enough to do that effectively, which I doubt, even under a left-leaning administration. The sort of scuttlebutt on that in 1982 was that some people were trying to love the Voting Rights Act to death, right? That it's so good, pre-clearance, we should just do it everywhere, right? As a sort of intentional effort to scuttle it and its constitutionality. I mean, the Supreme Court in South Carolina v. Katzenbach, when it reviewed the original 65 Act, found that the uneven treatment of the law, treating some states as violators that needed to be subject to preclearance, whereas leaving the sort of sovereign prerogatives of other states in place, was a feature in favor of its constitutionality, right? And that if instead you sort of try to apply that everywhere, you would intrude on state sovereignty so significantly that the Supreme Court would find that to be in excess of Congress's powers. I suspect the same would be true today. Coming up with a way to distinguish between the bad actor states that should be subject to preclearance and the ones that are not is obviously quite a challenge. There are two proposed bills that would do that in Congress today. A visiting professor here, Renita Tolson, who teaches election law, is actually testifying in the House Judiciary tomorrow in favor of one of those bills.
Great. This question is asked if you'll kind of speak to the impact and efforts of initiatives to defend voting rights for the incarcerated and people who have a record of felony.
Right. So one of the weird things about voting in this country is that we don't have a system of voting in this country. We have 51 systems of voting. When you try to explain this to people who come from other countries, they think that's just insane, right? That we have different rules in each state in terms of who's eligible, how you register, when you register, how you vote, when you vote. Felony disenfranchisement laws are one example of that. The diversity of laws here ranges from Maine and Vermont, which never disenfranchise you for any criminal offense. You can vote while in prison, to states like Kentucky, Iowa, Virginia, and until recently Florida, where you commit one felony offense, any felony offense, and you're banned from voting for life, right? 6 million people cannot vote in this country because of a criminal conviction. Caveat that based on recent events in Florida, which I'll get back to in a second. But that's a lot of people. Now, a quarter of them were in Florida alone, because Florida's a big state, and because Florida has one of the worst laws. It was 10% of Florida's adult citizen population. 1 out of 10 people, right, can't vote, couldn't vote in that state because of a criminal conviction. If you look at the black population of the state, it was over 25% of the black population and more than 30% of black men in the state unable to vote. Now, when you look at those numbers, right, how do you call Florida a democracy? I mean, now, what's amazing about felony disenfranchisement is that the laws have gotten more liberal since the Supreme Court in the 1970s, in a case, Richardson versus Ramirez, which came out of California, upheld the constitutionality of these laws. Back then, the Florida, Iowa, Kentucky rule was the majority practice among states. 1 felony, you can't vote. Only true in 3-4 states today, but there are more people disenfranchised today and a larger percentage of our population thanks to mass incarceration. Right? So again, if you just look at these issues through a democracy lens and you don't think about it, how it interplays in the larger political and social context, you can't understand what's happening. The laws are getting better, but felony disenfranchisement's getting worse. Now, Florida last year amended its constitution with over 65% of the vote to automatically restore voting rights to people when they've completed their terms of their sentences. 65, that's pretty remarkable when you think about it, because it means it's not just left-leaning voters supporting this, right? The Florida legislature came back this year and passed a law that, in their view, clarified that completing your sentence means paying off all fines, fees, and restitution associated with your sentence. We filed suit the day the governor signed that into law. Our preliminary estimate is that more than 85% of people who have finished their parole, right, still owe some fines and fees. Now, a lot of them probably can't afford it, but even if you can afford it, I mean, just imagine being told, you can vote, but you got to pay $500. I mean, how many people do you think are going to do that? Right? We have a preliminary injunction hearing starting 2 days from today.
The next question, I think, goes back to the Voting Rights Act of 1982 and seeks to explore further the motives behind Ronald Reagan and others in the Republican Party at that time for supporting the Voting Rights Act, the expansion of 82. The question asks, is it because of geopolitical pressure to appear non-racist against the backdrop of the Cold War, or were there other ulterior motives?
I mean, someone probably could write a book about that, and I confess to being a bit out of my depth in trying to understand recount exactly the political context at that time. I think, you know, as happens with a lot of things, and probably happened in 2006, once it looked like something was inevitable, right, opposition melts away, right, because, you know, why, you know, go down losing when you can instead just go with the flow and take credit for that thing that you never supported in the first place? I don't know.
Do we have any other questions?
I'm not saying that was President Reagan's strategy. I just like that was definitely some of those 98 to nothing votes, 98 to nothing vote in the Senate. Some of that 98, that was definitely the case there, I would say.
Okay, if there's no more questions, why don't we end with this? First of all, the first question is, what are some of the most innovative or best practices to encourage the inclusion of voters of color? And then maybe if you can wrap up, we have another big election coming up, and what can we all do, law students do, the law school do, to help make sure voters have their votes counted in 2016?
Sure. The affirmative reform that we favor more than automatic registration, which again I want to make clear, we support. Right? I don't want to catch, you know, arrows after this for saying that we don't. Is election day registration, right? So more than 20 states allow you to register at the polls on election day. There are a lot of reasons why we like that. One is, unlike automatic registration, it's technically open to everyone. It's not something that's limited only to people who interact with the DMV. There's good social science that shows that it's accompanied by an increase in turnout amongst young people, people who moved recently, voters of color. It's also, you know, something that can act as a safety valve if people's registrations got screwed up, you know, due to bureaucratic or administrative error, or people who got purged who think that they should be on the rolls but were removed. So we very much support Election Day registration, I think, as the most inclusive reform. Now, the parties don't love it, right? Because the parties want to know in advance of Election Day who's eligible to vote. They want to know sort of the universe of voters out there. And to be fair, like, part of me is like, you know, I mean, just get over it, right? But I mean, to be fair, look, get out the vote efforts do rely on having accurate lists of voters who you can turn out, and there's no list of people who are eligible but not registered to vote, so I can understand why some operators might not like that and might prefer something like automatic registration instead. There is actually no shortage of opportunities for people with some legal training to be involved in election protection efforts. The umbrella effort that a lot of civil rights and voting rights and good government groups participate in is the Election Protection Program, EPP, run by the Lawyers Committee for Civil Rights. They will set up basically hotlines for different states and triage problems as they happen, both at like the national level and within states. The way it basically works is you get trained up on the election laws and the types of practices or problems that happen in 1, 2, or 3 states so that you can fit into one of those boxes during early voting on Election Day, and then you field calls and try to troubleshoot problems as they happen. But that's, I think, the easiest way to protect people's voting on Election Day for people with some legal training.
Great. Let's give a big round of applause. And before we break, I just want to say kind of 2 more quick thank yous. And I wish Dean Manukin had been in the room, but for the first time ever in 2020, the law school will not have classes on Election Day, so students can participate in voter protection. And that initiative was really led by one of our students, so we want to thank Sunny for making that. So Gail has a full calendar of events the next 2.5 days. You can see it on the beautiful digital sign outside or elsewhere, but if you want to interact with them in a more intimate setting, be sure to take a look at the calendar. Is there anything else, Karen?
So I think that's it. Well, I will just say, I will plug that if you're interested in more about his career path, he talked about it a little bit. There is actually a lunch for students only on Wednesday, so please RSVP for that. And then he will talk more about the census case, I think, and other Supreme Court decisions tonight at whether the court. So many opportunities to hear everything that's going on in Dale's brain over the next few days.